Good afternoon, everyone. Welcome to this little video or webinar on mental disorder and the law, or I think we named it something like navigating part 20.1 of the criminal code. It's my great pleasure to introduce our guest, Mr. Justice Richard Schneider, who is he's the judge of the Ontario Court of Justice and is as well chair of the Ontario Review Board. Fortunately, we have the benefit of having him here as a deputy judge of the Yukon Territorial Court. So, I've known Justice Schneider for since 1999, when he was counsel to the Ontario Review Board at that time, and I've attended many conferences with him. I can confidently say that he is probably, there's probably nobody in Canada better equipped to speak about part 20.1 of the criminal code and the mental disorder law that, as it relates to criminal law. So, and just in case those of you who don't recognize me, my name is Rick Buchan. I have not practiced in the criminal courts per se for about 30 years, but I've chaired the Yukon Review Board. I was first appointed in 1999, and except for a 4-year hiatus, I've been doing this ever since, and I obviously, I guess, enjoy what I'm doing and the population we serve. So, anyway, we're going to start off with Justice Schneider giving you a quick overview on how review boards get their clientele and the different ways they come to us, and then we'll just progress on from there.
Well, thank you very much, Rick, and thank you everybody for attending. I think it's our intention today to give you a sweeping sort of overview of the scheme and how Part 20.1 works, and in particular how things work vis-a-vis the review board. I must say I always love getting to the Yukon. It's such a beautiful part of the world, and we've got some beautiful, not like we get in Ontario, nice dry snow falling down. You don't know how lucky you are. In any event, on with business. What we thought we'd first do today is just talk a little bit about the legislation that we've got in a very broad form, where it is, what we've got, and how it came to be. I call it the new legislation, which dates me because it was proclaimed on February the 4th, 1992, Bill C-30. This was a massive redo of the legislation pertaining to how the criminal courts manage individuals with mental disorder. It came in the wake of Swain, Supreme Court of Canada's decision in Swain. I won't get into the intricacies of that, but in a nutshell, the Supreme Court found that the failure of the legislation to provide a minimum window of time within which an accused status had to be reviewed post-verdict, NCR or NGRI, as it was in those days, not guilty by reason of insanity, ran afoul of various charter guarantees, and they looked suspiciously at other provisions, which caused them to send the whole works back to Parliament, and they returned with Bill C-30, which is LC30. It's the little mini code. It's part 20.1 of the criminal code, essentially, although there were updates to the criminal responsibility provisions in particular. And for the first time, we had a codification of the rules pertaining to fitness to stand trial. So part 20.1 of the criminal code is I like to think of it as a little mini code within the big code that tells you everything you need to know about how to deal with mentally disordered accused, or those who are thought to have some kind of mental disorder and find themselves before the criminal courts. So that's just a little bit of the background. As to how customers, if I could put it that way, come to the review board, of course, the review board is a quasi-judicial administrative tribunal. It's a statutory court. It can only do what the statute says it can do. And the review board has jurisdiction over two types of individuals. Those who have obtained verdicts of either unfit to stand trial, which is, as I said, now defined, codified. The common law was codified. It's contained in section 2 of the criminal code. And those who have been found not criminally responsible on account of mental disorder. That didn't change with Bill C-30. The provisions are still contained within section 16 of the criminal code. The unfit accused, of course, remain subject to the jurisdiction of the review board so long as they remain unfit to stand trial. When the review board comes to the conclusion or is of the view that the accused is no longer unfit to stand trial, the matter is returned to the court so that it can be retried. The review board does not revisit the verdict, but only offers advice to the court if and when they come to the conclusion that, from their perspective, the accused appears to be fit. Once the court retries the matter, the finding of unfitness, of course, has to be displaced on a balance of probabilities. And if that occurs, the jurisdiction of the review board terminates immediately. If they fail to find on a balance of probabilities that the accused has returned to a state of fitness, the jurisdiction of the review board remains unchanged. And whatever disposition or process was in place prior to returning to court, it continues in place until the next review. With respect to the those who've come to the review board with a verdict of not criminally responsible on account of mental disorder, the board maintains jurisdiction there so long as the state can show that the accused constitutes a significant threat to the safety of the public, which is, as well, you'll find defined now in part 20.1 of the criminal code. Both unfit to stand trial, those verdicts of unfit to stand trial and not criminally responsible on account of mental disorder, are obviously driven by the finding of mental disorder. Mental disorder is as well defined in section 2 of the criminal code as disease of the mind. Now, disease of the mind is terminology that dates way back, and I think it was deliberate that the definition was simply left to disease of the mind, because with that, it imports a tremendous volume of case law that predates Bill C-30. And the Supreme Court of Canada in the Cooper decision has defined disease of the mind to include pretty much anything, any disorder, abnormal condition that I don't have the provision, the case cracked in front of me, that affects the psychological functioning of the accused. And that's a paraphrasing, I apologize. So mental disorder, the presence of mental disorder, whether we're talking about unfit to stand trial or a lack of criminal responsibility, is a necessary but not a sufficient condition. The mental disorder has to take the accused over certain thresholds. Either they're unable on account of mental disorder to conduct their defense or instruct counsel to do so, or they fail to appreciate the nature, consequences of their act, or to know that they're both morally and legally wrong, as you'll see in section 16 of the criminal code. So that's essentially how, subject to questions or things that I may have missed or misspoken about, that's essentially how individuals come before the review board.
So I think it's important to note as well that well, first off, looking at the nature of the board, which is defined in the in part 20.1 of the code. The board is a specialized tribunal, and the legislation mandates that the board be comprised of in terms of panels, and then some jurisdictions go with panels of 3, others go with panels of 5. But in any event, every panel must have at least, as the chairperson, either a judge, a retired judge, or a lawyer with the qualifications to be appointed as a judge, which essentially would mean, practically speaking, somebody with 10 to 15 years at the bar at a minimum. The other mandatory component is to have a psychiatrist, which sort of balances out the, between the chair and the psychiatrist, you've got both the legal aspects and the psychiatric aspects covered. And then the third member preferably should be somebody with some background in whether it be psychology, health, medicine, social work, those kinds of things, so that you get a spectrum of expertise to bring into consideration in each case. The review boards are, although we are constituted under the criminal code, by virtue, which is federal legislation, the code deems that boards are, they are appointed pursuant to provincial or territorial legislation, and they are deemed to be provincial or territorial bodies. And unlike the courts, review boards function on a civil standard of proof, balanced probabilities, and not proof beyond a reasonable doubt. What else we got? Now, except for a few provisions in Part 20.1, the board shares essentially concurrent jurisdiction with the courts, whether they're territorial provincial courts or superior courts, in terms of kinds of orders that can be made. I won't get into the details of which orders are reserved for the courts, but they may come out in the course of our discussion anyway. Another important consideration is that so long as a person is under the board's jurisdiction, that jurisdiction is continuing jurisdiction, in the sense that after a hearing, when the board makes a disposition order, it doesn't become functus officio. The jurisdiction doesn't stop there, as it would following a court's decision on a verdict on a criminal charge, for example. There is explicit provision for matters to be recalled before the board, which is typically how things go anyway. Dispositions generally are for a maximum period of 1 year, except by consent of the parties, where it can go up to 2 years. But Um, but if there is a change of circumstances, parties can apply to the board to bring the matter back earlier. For example, if the condition of the accused takes a sudden turn for the better, maybe a change in medication or whatever, and they've suddenly develop insight into their mental disorder, or it could go the other way, and if their condition is, they start to decompensate or engage in behavior that increases their risk to the public, the matter can be called back, and that can be done on the application of any of the parties, or the board itself can, on its own motion, convene a hearing if it feels that circumstances warrant.
Right. On that point, Rick, and that's exactly right. The hospital, though, well, first of all, the starting point is that all dispositions are reviewable not less than once every 12 months, unless, as Rick was saying, the consent of the parties then go to 2 years, right?
Yeah.
Yeah. A couple of events that might occur within the 12 months that could trigger a review are, well, first of all, the hospital, as of right, can have a review anytime within the 12 months. That is as of right. There's no discretion left to the board. Defense or AG may apply for an early review. Typically, again, as was mentioned, if it's felt by one of the parties that circumstances have changed such that there's reason to believe that the current operative disposition may no longer be appropriate and that it requires some tweaking or altering to better fit the accused and their circumstances. Also, obviously, with the unfit accused, if word comes from the hospital that the accused's rehabilitative trajectory has taken them to a state of apparent fitness, that then again would also put the accused on a list for consideration by the board. The other not so uncommon event is when the hospital restricts significantly the accused's liberty for a period that exceeds 7 days. So operating within the discretionary envelope that's been provided by the board against their history leading up to changes in their circumstances dictated by the hospital. If those changes are significant, and that has to be determined by the hospital, and if that significant restriction persists for more than 7 days, the hospital is obligated to notify the board, and the board will then step in to review the discretion of the hospital as soon as practicable. So those are just a few things that might occur within the 12-month window that would cause the board to revisit the accused situation.
So probably at this point, it would be good to go to sort of the central part of Part 20.1 that defines what the board can do. That section is section 672.54, which deals with dispositions, whether they be by the court or by the board. And I'll without getting into all of the subject to this, subject to that, references to various sections. The key point is that when a court or review board makes a disposition, it shall, now this is the key point, taking into account the safety of the public, which is the paramount consideration. So that's number one criterion, that public safety is paramount, but that does not you can't take that to extremes that unduly entrench or sorry, trench on the liberty interests of the accused, and that is here's where the other criteria come in. So public safety, paramount consideration. Then they must take into account the mental condition of the accused, the reintegration of the accused into society, and other needs of the accused. Make one of the following dispositions that is necessary and appropriate in the circumstances. So for somebody who is in the status of not criminally responsible, NCR, by reason of their mental disorder, if the court or review board considers that the accused is no longer a threat to society or a significant threat to the safety of the public, that entitles the accused to an absolute discharge. You're done with the board, the court, whatever. That is subparagraph A.
And that's not a reviewable disposition other than by the Court of Appeal.
Right. Yeah. That's the point at which the review board does become functus in terms of its disposition. Once the accused is absolutely discharged and out the door, that's it. Second is that the where the threshold of public safety, and we'll get to that in a minute because it is a relatively recently or more recently defined term in the code, but where that threshold is determined by the board that the person is still over the threshold of public safety risk, there are two other options available to the board. One is a conditional discharge, which in some respects might be analogous in the criminal court system to a probation order, but it can go further than that in terms of the conditions under which the accused may be required to live and so on. And then finally, where the person's mental disorder is severe enough that it requires closer custody and a therapeutic environment, then the subparagraph C provides that the board or the court may order the person detained in custody in a hospital, subject to such conditions that the court or review board considers appropriate. And typically that hospital, well, there is a provision for so-called designated hospital, which allows each province and territory to designate certain hospitals for the purpose of dispositions under this part of the code. As anybody who has been before the review board in this jurisdiction, you'll know that we have two existing designated hospital facilities, one of which is Whitehorse General Hospital, and the other is Whitehorse Correctional Center, which sort of create a bit of a spectrum of facilities with different levels of security and therapeutic value. Now,
can I just
yeah,
throw in
jump in.
Just a footnote on necessary and appropriate. The board is charged with, after blending those four factors that Rick alluded to, keeping the safety of the public as the paramount concern. After stirring around that pot of considerations, the board is charged with coming up with the disposition that in all of the circumstances is necessary and appropriate. That replaced 7 or 8 years ago?
2013.
2013, thank you. The threshold was described as the least onerous, least restrictive disposition. The terminology was, excuse me, the terminology was changed for reasons that elude most of us, but nevertheless, they're said to mean the same thing.
Yes.
And that requirement that the disposition be the necessary and appropriate or least onerous, least restrictive disposition pertains not just to the broad form of the disposition, but to each of the terms contained within the disposition. And just with respect to, this is something that's commonly misunderstood, I think, at least in my home jurisdiction, perhaps not so much up here, but it's typical, as Rick was saying, that these orders will stipulate the broad form of the disposition, then articulate a number of different terms and conditions and things that the hospital can do or might not do. These are to be interpreted as privileges that may be extended at the hospital's discretion to the accused, rather than rights that the accused can insist on enjoying. So whether or not a particular term or privilege is appropriate depends on a number of things, as you might imagine. The clinical condition of the accused, whether the infrastructure is in place to effect that sort of a privilege, etc. So if all of the stars align, the administrator may elect to extend a particular discretion or privilege to the accused. They aren't, as I was saying, rights that the accused can insist upon. Do we have a question coming in?
Yeah, we got a couple here.
Okay.
Okay, so one from Bruce Warren's. Can an accused or a person under board jurisdiction apply to the board if their liberty is restricted, perhaps if the hospital fails to report to the board? So yeah, you deal with hospitals much more than we do. So why don't you answer that question?
Yes. Well, the Ontario Court of Appeal just dealt with that very issue. And it's only the hospital that can call a significant restriction, call it a significant restriction of liberty pursuant to the statutory provisions has occurred, which would trigger the review. So I take the question to be, well, what if the hospital fails to notify the board? The board on its own motion can't trigger an ROL, I would submit, nor can the defense. However, the defense can make an application for the matter to be reviewed, and the board can on its own motion cause a review to be held, and that can still be based on the same information, even though the wording isn't the same. It wouldn't, formally speaking, be a restriction of liberty hearing, but it could be an early review triggered because of at least a prima facie case that for whatever reason the current disposition wasn't working, wasn't holding the accused appropriately, or was for whatever reason not a good fit. So the answer to the question is yes. You have another one here.
Yeah, this sort of follows, and this would be in reference to 672.56, right?
Right.
Significant.
Well, how does a defense lawyer learn what the particular hospital defines a significant, quote, significant change in the restriction of liberty? Well, the Court of Appeal Ontario has indicated that that's assessed against the accused's so-called liberty norm. In other words, prior to the change coming about, how was the accused ticking along? And relative to that, how have the changes impacted upon the accused? I think it's noteworthy that, and I think we can assume that somewhere along the line, and it's a good question, but somewhere along the line, there's obviously a difference between restriction simpliciter and significant restriction. So the question is, what moves one from restriction simpliciter to significant restriction. And I think that has to be assessed in a contextual way against what the accused liberty norm was. So what a change that might constitute a significant change for patient A might not for patient B, depending on what their liberty norm prior to the change looked like. So there you go. I know that I didn't answer your question, but it's a contextual assessment. And like mostly everything else, it's up for argument. The case, by the way, to look at from the Ontario Court of Appeal, to the extent that you might think the Ontario Court of Appeal has anything worthwhile to say, is Campbell. And that really set in play a layer of considerations that weren't formally set out before. In response to that, the Ontario Review Board posted on its website a practice direction as to how these so-called Campbell matters pertaining to significant liberty should be handled, at least so far as the Ontario Board is concerned. I don't know that you necessarily want to import that to the Yukon, but it might be of interest at least.
Okay, Christiana's asking another question.
Okay.
How does defense counsel?
Where did that question go?
Into the cyber void. Here we go. How does defense ensure they have all the information to determine if there is an issue? Do we request disclosure of hospital records?
Well, I'll tell you what happens in Ontario, and then Rick, you can talk about what happens here. As counsel, you would typically have access to the accused clinical record. So it would be, you'd be free to go to the hospital, rummage through the chart, look at the nursing notes, see what's happened, and make an assessment of your own.
We don't have the convenience here of a local forensic hospital. In practice, what we often do in our dispositions, in our hospital dispositions, we have a situation where the director, there's a director of mental wellness and substance abuse in the territory, and that is the government official who's sort of responsible for managing review board clientele for the most part. I think that would be that would certainly be the case with people under hospital dispositions.
Right.
We typically put in our disposition order that in order to sort of keep everybody up to speed with how the individual is doing in hospital, we require the hospital and the director's representatives to be in consultation with one another.
Right.
And we have a mechanism that we call the plan. So the so-called plan, sets out a number of things, but where we've got somebody in hospital, the terms there require that the hospital and the director consult.
Okay.
And so practically speaking, if counsel wants to find out how their client's doing in hospital, they could, in terms of going to somebody locally, they could contact the director or the director's.
Sure, and
team,
and for that matter, there's no problem with picking up the phone and speaking to your client's treating psychiatrist. And they would typically be, I think, quite comfortable in talking to you as much as anyone else. But you can always try that on.
Yeah.
I think something else just popped up.
Christiana asked how we get the information. 672.56 is the one that deals with restrictions of liberties. And that has the notice provision there, but apart from restriction of liberties, notice, if there's no restriction of liberties, then as Justice Snyder said, contact the psychiatrist or contact the forensic complex care team here in Whitehorse. Anyway, yes, I think she's got the answer she wants. She has to ask.
Okay.
Yeah.
So what's next on our list of things?
I thought we should probably just going back to the definition of risk, significant risk. That is
672.5401.
Yeah, 5401. Okay.
This, by the way, was set out pretty clearly in the leading decision on part 20.1. It was probably the first significant decision from the Supremes and remains probably the go-to case. Comes from 1999. Nevertheless, Parliament in its wisdom chose to legislate on top of that. I hate reading statutes, but I guess there's really no substitute. For the purposes of section 672.54, a significant threat to the safety of the public means a risk of serious physical or psychological harm to members of the public, including any victim of or witness to the offense or any person under the age of 18, resulting from conduct that is criminal in nature, but not necessarily violent. So I don't know that codification adds much to what our previous understanding was from 1999 on. Rick, do you see?
I don't know, I mean, this foundational case in 1999, Regina and Winco, is definitely the go-to case. And I'm going to, I've downloaded a few cases that I'll give to the Law Society to make available by some means, whether they're emailed out to participants or available somehow. But Winco is definitely the one that anybody practicing in this area should start with, because it sets out a number of important things to remember. Things about the lack of, there's no onus, for example, there's no onus on the accused to disprove their risk. The review boards must operate on the evidence that is before them. Court points out that the boards are inquisitorial in nature. And if the board does not have the evidence that it feels it needs to get a better understanding of the nature of the mental disorder or the risk or whatever, then there's an obligation on the board to go out and seek it, often by ordering a risk assessment report or whatever. That decision also points out that the board is entitled to draw on the entire body of evidence, and depending on how long an individual has been under the board's jurisdiction, and sometimes it goes on for years, that there is an accumulation of evidence, so that you have to take things in the broad spectrum, because risk is not always evident on the surface, and sometimes it may appear that somebody under a conditional discharge, they're going to their appointments, they're taking their meds, they're not breaching any of the prohibitions against substance use or carrying weapons or anything like that. one might look at that and say, oh, you know, they're doing good. They're no longer a risk. But that is only sort of a small window, often more recent. And that is as much evidence of lack of risk as it is that the conditions that are managing the risk are doing what they're supposed to do. So it's important then to look at the entire spectrum of evidence and find out what is more relevant right now. There are risk assessment tools that that help psychiatrists and boards and so on understand at a more subtle level how that person's risk profile measures up.
Can I just jump in with a couple of little footnotes? Back just to significant threat to the safety of the public and the statutory definition, which was included in 2013. The one change I think I remember is that the statutory definition speaks of a significant threat to the safety of the public means a risk of serious physical or psychological harm. I believe Justice McLaughlin said a real risk of serious physical or psychological harm. Now, whether much turns on that or not, I don't know. But I think what it does import is the idea that Parliament wanted this to be more within the realm of possibility, whereas Justice McLaughlin, I think, arguably might have been talking more about real probability. Nevertheless, that's something that can be argued about. As Rick was indicating, we are an inquiry and are obligated then to ensure that we have, I'd put it this way, a sufficiency of evidence to make a disposition. If we don't have a sufficiency of evidence, then we may have to ensure that further and better evidence is brought to us. It doesn't mean that we're obligated to flip over every rock. That can go on forever and ever. But so long as the board is in a position where it feels that there is a sufficiency of evidence, it can proceed. The other point, Rick made a very good point with respect to, especially the courts of appeals, I would say. They'll end up with an argument from counsel that, well, Mr. Smith has been 6 years subject to the Yukon Review Board, and I've looked through the file and there doesn't seem to be any incident of bad behavior or anything that could be classified as a significant threat to the safety of the public. But then what you have to do is consider the supports and the supervisions and the various structures that are in place around the accused, propping them up. And there's a real distinction to be made, as Rick was saying, between risk well managed with all of these supports and what have you, and no risk. So the simple fact that there have been no incidents in the hospital report doesn't, I would submit, end the matter. You have to see what sort of supports and structures were propping that accused up. And normally what you like to see is a gradual removal of the supports around the accused in a titrated way to see how they can manage with more and more independence and autonomy, to see whether that pattern of not being problematic, see whether that is maintained by the accused on their own steam. Sorry for those.
No, that's
Yep.
We could probably go on for
Yeah.
3, 4, 5 hours. We've got an hour and a half, so we're halfway through. I think we're doing all right.
Okay.
We do want to leave time at the end for more Q&A.
But if questions do come up along the way, by all means, shoot them to us, because they'll fit more logically, obviously, with what we're currently covering. So don't be bashful.
So, so just going back to how the board handles the two different categories of clientele, unfit and NCR, or not criminally responsible. So a typical scenario may be that obviously the entry point of the individual into the system is an appearance before the court. If the court judges the individual to be unfit, that may, that finding may be accompanied by an order that the person spend a period of time in a designated hospital, and may include an order by the court. And this is one of the provisions where the court uniquely has the jurisdiction and the review board does not. That is to order the person be subjected to medication to help them regain their fitness. And depending on the medication or whatever, that can be regained relatively quickly, and depending on the medication and the state of the individual's mental disorder. But assuming that works, and what is it, 60 days is a typical order for that?
Treatment orders, we routinely do them in Ontario, and in particular at the mental health court in downtown Toronto.
Right.
It is almost a certainty that upon a verdict of unfit, the Crown will bring an application for a treatment order. The court has to be treating those very seriously. I would submit they're probably the most invasive orders a court can make for the involuntary injection or ingestion of psychotropic medication, which incidentally, being criminal code provisions, would run over any other civil legislation that would pertain to treatment capacity and things of that sort. Those would not be considerations. The authority of a treatment order from the court would be absolute. And the treatment orders are for a limited purpose to render the accused fit and for a limited duration of up to 60 days. In my experience in the court, I would typically make the order for 60 days, but bring them back at 30, knowing from experience that if an accused begins to receive olanzapine or whatever it is, and if it's going to have an effect, that will be apparent at 3 to 4 weeks.
Yeah.
And so bringing them back at halftime, generally speaking, if the treatment had its anticipated effect, the accused will present as fit and the matter can be reviewed by the court, and they may move on their way to regular prosecutorial stream, enter a plea, or move on in any way that's appropriate in the circumstances. And I don't want to sound like I'm a strong advocate of treatment orders, but something to keep in mind is, though, at least in Ontario, and Rick, you can talk about the timelines here. If an accused is found unfit in Ontario and a treatment order is made, they'll typically, and I'm picking a number out of the year, I would say 90% of the time, they'll be rendered fit within about 3 to 4 weeks. They'll come back to court and they'll be able to move on. If that same accused with a verdict of unfit goes to the review board without the benefit of a treatment order, by the time the accused gets installed wherever they might be pursuant to a review board disposition, and by the time territorial or provincial legislation, civil legislation is engaged to start treating them, the turnaround back to court is in the range of 3 to 4 months, or perhaps 6 months. So from both a resources perspective, that is hospital beds, and from a liberty perspective, how long the accused is jacked up as unfit, I think there's a business case for these orders, even though they are, as I said, vehicles that need to be treated with a high degree of respect, because they are obviously inherently powerful and extremely intrusive.
Yeah. And I think it's fair to say as well that the sooner somebody's situation is regularized, in the sense that if they can quickly get back to fitness and then get through the courts, and typically what we find is that they commit the index offense, whatever that may be, under in a state of unwellness, which often will be quite obvious, judging from what we see from police reports and court's judgment and so on. So they get from the offense into court is relatively short to deal with the unfitness. If the court orders, makes a treatment order and gets them sort of back on the rails, so at least they're fit and can get back before the court to have their fitness adjudicated, then they will, once the accused is fit, then they'll try the case on whether or not they were not criminally responsible at the time of the offense. And if that finding is made, then the court will, and even though certainly in this jurisdiction, even though the court has the authority to make a disposition order, I can't recall in 20 plus years ever seeing the court do that. The courts, judges typically recognize that the review board has the specialized expertise and so on, and they're quite familiar with dealing with people, and they're often try to expedite getting them to the board. And
there's some reasons for that. It's true, as Rick was saying, that upon a verdict of either unfit or NCR, the court could make a disposition at first instance. The court must hold a hearing if a party requests. And you could take a look at the provisions of 672.45. But the court only makes a disposition if it's able to readily do so. And typically before the court at the time of the verdict is only the report going to the psycholegal issue of either fitness to stand trial or criminal responsibility. In order to get into the business of least onerous, least restrictive disposition, a separate report would have to be ordered. And so for that reason, why not leave it over to the review board, which has to hold a disposition or hold a hearing and issue a disposition within 45 days. That's the number one consideration. Number two consideration is that outside of big urban areas where there's a lot of volume, judges are nervous about this sort of thing, because they don't see a lot of them, and it's an unfamiliar world. And what defense counsel know is that when judges, sometimes, not me, of course, but some judges, when they're not sure, they tend to be cautious and they make careful, perhaps conservative decisions. Whereas letting the matter go to the review board, and we hold 4 hearings a day, 5 days a week, over 2,000 hearings a year. This is very familiar territory. And so from counsel's perspective, there's a great inclination or a great, I think, preference to have the matter go to the review board and then have the court fool around with it and perhaps issue a disposition that's overly conservative. Mm-hmm. So,
yeah. And of course, once they get to the review board, then there is the ability to issue dispositions that often will take care of not just managing the risk, but also, assisting or making orders or conditions that essentially require the territorial provincial government to provide appropriate accommodation for the person, supervision, counseling, treatment, and so on, which, for somebody who may have a long-standing mental disorder, there's a lot of people living on the streets with these kind of conditions. Certainly it's not stereotypical as such, but for those who come into the system without having a stable background or stable living situation, getting them into whether it's into a group home or some kind of supervised living situation or whatever, getting them supports, counseling, therapeutic intervention in one way or another makes a huge difference.
Yeah.
It makes a huge difference, and these kinds of conditions and so on. If they're in the court system and they're just going through the normal criminal justice system, the courts don't make these kind of orders.
Right.
They make constraining orders that say thou shalt not do this or do that and keep the peace and be of good behavior. And this is a consideration. I remember when I was first appointed, we had, at that time, I think we had about 5 or 6 cases before the board. And I learned that the defense bar at the time was very wary of the review board and maybe it was just the holdover reputation of the old system, the lieutenant governor's warrants that just put people in a hospital indefinitely.
Right.
And they were very concerned about liberty interests and concern about their clients being under the board, for an indefinite period of time as well. Not recognizing, I think, that the board has a lot of power to be able to make life better for these individuals. So, instead of somebody with a mental disorder who keeps, either having, substantive offenses or those that just keep breaching probation orders, for example. And just, they're in the revolving door at remand court. I think they started to see that these conditional dispositions that got them, taken care of and so on, that was in the best interest of their client, not looking at narrowly at purely at liberty interests, but what is quality of life issues. Yeah. So thankfully that cautiousness that we used to see has dissipated significantly.
I think we've got some.
Yeah. What do we got here?
Let's see.
Oh, geez.
Let's deal with these.
Okay.
Did we deal with?
Oh, yeah. Okay.
Sorry.
Yeah. Mouse here. Ooh, it's a long one. Darcy.
Let's go you want to go to the top?
Yeah. Okay. That's okay. So after Christiana is Darcy.
Okay. And what does that say here for the benefit of the audience? Another challenge I faced involved the imposition of treatment bracket typically medication, but sometimes more intrusive treatment on accused on a hospital disposition outside the Yukon. Although the review board does not have jurisdiction to impose treatment, the outside provincial hospital would often use provincial mental health legislation to justify or allow treatment. My concern is and was that the accused is only in that provincial hospital because the Yukon Review Board does not have access to a local forensic hospital. So sending them out subjects them
to a
foreign legislative scheme that can impose involuntary treatment. Please comment on the appropriateness of this situation. Well, do you want to take a stab at it, being the Yukoner that does these things?
Yeah, well, I have to say, it's not a frequent issue that I have seen.
Right.
Occasion, and it's usually, I think, at the outside or the outset rather of a hospital disposition where the client is sent to the hospital. They may be floridly psychotic and causing harm to others or maybe harm to themselves. I mean, those are the criteria typically under provincial territorial legislation. So when I have seen it, typically the Mental Health Act involuntary treatment is quite short.
Mhm.
And then once they sort of get stabilized, then they're on the.
But and again, I guess, and I hope, Darcy, I'm not missing the point, but just a trite observation: if you're driving from Manitoba through to Quebec and you stop in Ontario and you decompensate and you find yourself an involuntary patient in Ontario, you're of course subject to whatever the civil legislation might be in Ontario while you're there, regardless of how you got there or the purpose. I get the point, though, that a Yukoner accused may only be in Alberta because of the disposition issued by the board. But I gather there are contractual relationships with Southern hospitals that put them there. So they are designated facilities within the meaning of Part 20.1. And while I definitely do appreciate your logic path and concern, I think that's something that the hospital, the designated hospital, is obligated to engage for the benefit of the accused. They're obligated to provide whatever they can in terms of a rehabilitative program and to engage civil legislation if and when required. So who's next?
I think this is still Darcy.
Towards the top of that one.
I think what Darcy is getting at is where somebody has found, the fit but fragile provisions.
What's that?
Where an unfit person is under the board's jurisdiction.
Yeah.
The board finds them fit.
Yeah.
But their condition is pretty fragile.
Right.
And there is a risk that if they are simply referred back to the court without some sort of supporting conditions, they'll decompensate. Yeah. And so, yeah.
Well, and again, I don't know what the convention here is. In Ontario, the jurisdiction of the review board is alive and well and uninterrupted until the court finds, on a balance of probabilities, the accused has become fit. So an order that an accused returned to court does not interrupt or stall the disposition that the accused is on. It just means that they're put on a docket, and on the assigned date, they make a trip to the court from whatever hospital they were at. So it's not like they're being sent off to a remand center or anything of that sort. It's simply an appearance at court for the purpose of revisiting that verdict. So while I take it that even that is not great, because it means being transported on the day of to a court for a retrial of the issue. And I have seen, as a few lifetimes ago, as defense counsel, people, and I take your point, Darcy, unraveling from the time you see them in the cells to the time they get up into the courtroom. So yes, things can happen in the decompensation world very, very quickly. But I would say that it's a relatively rare event. And in Ontario, that order back to court is just for, well, not momentary, but it's a quick trip. So the probability of misadventure is minimized. I suppose where that quick trip in Ontario here might mean a considerable bunch of travel, I don't know. Perhaps that could better than be handled with the AV hookups or something. I hope I'm not speaking out of turn.
No, that's yeah.
Because that's an easy way to get around that potential hazard of having someone on their order to go back to court come apart, for lack of a better way of putting it.
Yeah. Typically, I think here, because of the difficulties associated with our clientele being in an outside hospital, we tend, even with unfits, we tend to try to have them on conditional discharges, because we have the director, is we call her, who oversees this forensic complex care team. The forensic team actually can provide some very good support services, and including they've got a psychiatrist, right, as part of their working group, and so even unfits can be handled more often, I think, than maybe perhaps the practice down south. So I can recall a few occasions where we found somebody is fit, and we're on the third floor across the atrium from the courthouse, or the law courts, and often if we've got a morning hearing, often the person could be back in court at 1:30 in the afternoon. Sure. And so there's a kind of a good working arrangement there to get people moving along as quickly as possible without undue delay. This one from Christiana.
In Ontario, have you seen First Nation communities applying to be parties to the proceedings? What about in the Yukon, as some
First
Nation clients are sadly sent across the country for indefinite periods? I'm honestly, there are, of course, as I'm sure council's aware, there are provisions in Part 20.1 where applications can be made to obtain party status. I'm embarrassed to say that I'm not aware of any of those happening, and they might very well have. We hold 2,000 hearings a year, and at 11 different facilities, and that may very well have occurred. I'm not aware of it. Rick?
We've had First Nation or First Nations, or the First Nation Council of a reviewer client apply to be a party. We've made made one a party in the past. The chief showed up regularly at hearings and so on, and that was that provided a lot of support, just even moral support for the client. It's not something that's happened frequently. We do encourage, and a majority of our clients are First Nation.
Right.
So, and some of them are from outside communities that where they've got family and so on, and nobody, not a lot of family locally. So we do try to encourage participation and enable the accused to access their community and traditional activities. And
well, we certainly,
so,
I know that we certainly have a keen eye on that aspect.
Yeah.
But formal designation as a party, I wish I could speak to it better, and I apologize, counsel. Had I known of the question, I could have had it researched for you and given you an answer, but I'm apologizing. I can't report.
Yeah, I mean, there are some downsides that in being a party that an applicant First Nation may not realize. I mean, as soon as you're a party, you're subject to the board's orders.
Yeah.
And you should sort of go into that with eyes wide open. But some First Nations have been willing to try to provide some kind of in community social service supports. Probably having to rely a little bit on the territorial government for some assistance in that area, but it's conceptually feasible.
Right.
But First Nation can provide a lot of support to their citizen without being a party.
Yeah.
And so it's not something I would certainly encourage, off the cuff, unless the First Nation really knew what they were getting into, because I think, without taking on those obligations, the First Nation can still do a lot for their citizen.
Sure.
In other ways.
What's that one there? 3 new messages.
Yes, we got.
Okay. What are your suggestions?
They're all coming in. Okay, Christiana again.
Well, I think that's this. I think we may have covered that. Council in Ontario are very alive to this issue, and it goes much further than culturally appropriate programming. I mean, it goes so far as I know we have a number of clients, patients from Nunavut, for example. So it goes so far as to having the hospital bring in traditional foods. We're very mindful of the fact that the restorative process is complicated, and it's not simply a matter of gobbling pills. We're very, very mindful of those issues. And I think try to do our best. As you can imagine, sometimes the logistics are challenging, but all I can tell you is that we're doing everything we can on a case-by-case basis. What do we have
This is
here?
from Bruce Warrensby.
I believe that there is wide authority for Yukon First Nations to have a role in the review board, particularly under the AJA. What's that?
What is it? Access to Justice Agreement?
Okay. Now, to what extent that First Nations wish with to occupy the field? I'm not too sure.
Okay, yeah, no, this arises out of First Nation settlement agreements.
Okay.
Where First Nations have the potential under their agreement to assume areas of jurisdiction over various subject areas.
Okay.
And part of the process is entering into a administration of justice agreement, AJA, for that subject area. So I think the issue, is a big one. Lack of resources is one reason why the First Nations are not suddenly saying, well, we're going to take over social services for our citizens or whatever. But,
what's this one?
Okay.
Justice Schneider kindly
Advise. Here we go. Scroll down.
Would Justice Schneider kindly advise me of how the review board maintains jurisdiction following a fitness finding? Well, if you mean a fitness finding by the board, that isn't a revisit, that isn't a retrial of the issue. I would concede that the wording in the code is unfortunate, but the first part of any hearing, whether it's with respect to an unfit or an NCR, first part is jurisdiction maintained. Second part is what's the necessary and appropriate disposition conceptually. I know they roll out in typically a much more clumsy fashion, at least in Ontario, not certainly here in Ontario. But the board's view that the accused, I use the term advisedly, view, and I know that's not the term in the code. All we're offering to the court is our recommendation that from our perspective, on last viewing the accused, he appears to be fit. We do not retry the issue. And because we don't retry the issue and upset the verdict of unfit, the jurisdiction of the board is similarly not interrupted, because our jurisdiction maintains so long as a verdict of unfit is in place. And it's only the court that can undo that on a balance of probabilities. So I hope that answers the question. But it's a good question. And some are of the view that the review board, when they send someone back to court as fit, they've actually reversed the verdict. That is not the case.
Okay, what time have we got here?
We've got
1:19. We want to get through this. So let's just get a little more through our script here.
Okay.
A few important points. Well, one is on the topic of unfits.
Right.
In the 2013 amendments to the code, there was a provision added whereby somebody who is permanently unfit,
Demers, right?
Demers, yeah, and who, the board finds to be no longer significant risk to society.
Right.
This provision, I don't remember the section offhand.
0.851.
Okay, allows the board to make a recommendation to the criminal court to send the individual back to court with a recommendation that the board finds the individual to be fit and not to be a significant risk. So those are the two criteria that then triggers the court's review of the case. And I don't know if I'm really paraphrasing, but at that point, but it's ultimately the court that makes the decision to grant it. Absolutely.
Exactly. It's back to the court again. The review board's merely offering advice. And this legislative change comes from the Demers case. And the problem, of course, is counsel attending will all recognize, there are some cases of unfitness to stand trial, especially with respect to intellectual deficit, head injury, static conditions that just aren't going to change. So you have an accused who's come through the review board doors as unfit. Well, given that the condition is static, they're going to be there forever. And so you can imagine the constitutional challenges. I commend to you Demers, which sets the backdrop. But so what we've got with the amendment is the following. Where the accused is presently fit, appears to be permanently unfit, and it does not appear to be a significant threat to the safety of the public, deliberately importing the same language as used in 0.54 in respect of NCR accused. The review board sends the matter back to the court. And if they agree with that assessment, they would then stay the charges. And it's a great provision that should have been in there at the beginning. But it prevents the review board from warehousing people with certain sorts of mental disorders that really don't need to be there. And there were a tremendous load of those in the system, at least in Ontario.
Good.
Yeah, go ahead, Rick.
Okay, just getting through a few other points here. We touched earlier on again, the 2013 changes where Parliament got rid of the language least onerous, least restrictive that was up till then fully, that was part of the considerations, and put some vague language in its place. There's a court decision from the Ontario Court of Appeal called McAnuff, MCANUF 2016. You can find it on Canley, and they were pretty clear there that regardless of the legislation wording, that the least onerous and least restrictive is still implicit, and logically it has to be. It's necessary in order to comply with charter principles. So that's one. Now here's one that I think where practices differ across the country. There's a provision, I think it's in 672.5 about how which is what deals with the manner in which hearings are run. There's a subsection there that basically says hearings may be as informal as the board considers appropriate.
Right.
And this may give rise to different practices across the country in terms of their style and so on.
Yeah.
Here, we try to run our hearings really as informally as possible. Right. And part of that has to do, I think, certainly here and probably in other territories, there is a disproportionate number of people before the boards that are affected by FASD or other neurocognitive problems. And then and the other aspect is that there's, in the criminal justice system, there is a disproportionate number of First Nation people relative to the overall population. And a lot of people who have already gone through the revolving door with the courts are intimidated by court-like processes and so on. And so what we've tried to do with our board and our procedure is to try to remove some of the trappings of that to make people feel more at ease. Right. We try to, instead of having
evidence isn't sworn.
That's right. Yeah. And it's more conversational. The evidence gets out reasonably efficiently. We kind of bounce back and forth and so on. It may take a little bit more time sometimes to, get exhaust the conversation, as it were. But in the end, the focus is on the accused, it's on the board's client, and to try to make it easier, as easy as possible for them to not have an alienating experience. So I've even gone so far as to recommend that ties not be worn. I mean, not ordering it, but simply indicating that
Wasn't mandatory.
it's not a mandatory dress code. So I think the clock is running out on us. One last question here.
Let's see. It's down below here.
Okay, and down the line.
Okay. It's another challenge I faced involved the imposition of treatment to didn't we cover that?
We covered that one before.
Was there another one?
I don't see it.
Can you help us? Oh, is it in there?
Well, that's where we just went through.
Oh.
That's fine.
Can
It's
you tell
not
us
showing
what
up
the
here.
question was?
It's about the qualifications of a psychiatrist on the review board, like whether the psychiatrist is a specialized psychiatrist or a treating psychiatrist.
Right.
It doesn't specify
No, it
in
doesn't.
the code.
It doesn't specify. I can tell you again, in Ontario, our psychiatrists tend to be forensic specialists. I would say 95% of them are forensic specialists. And it's a bit of a problem. We have 11 designated forensic facilities in the province. It's very likely that the forensic psychiatrist is a staff psychiatrist at one of those facilities, but of course they can't sit at their home facility. So while there might be the odd psychiatrist who's not forensically trained, they would be few and far between. I hope that answers it. Okay.
Okay, well, soup to nuts. As I mentioned, I've got some case authorities. Winco. There's one called Regina and Lewis from the PEI Court of Appeal. Basically says the federal government creates this system, but it's up to the territories and provinces to discharge the responsibilities in terms of managing people. That is backed up further by a Supreme Court decision, Regina and Maze from BC, and it goes into greater detail about what the board can and can't do. Board has authority to grant broader parameters for particularly individuals in forensic hospitals and so on, but is not authorized to micromanage or stipulate specific treatments. That's left to the medical staff at the hospital. And then there's one called Regina and Conway, and it speaks to the jurisdiction of boards, which includes deciding charter issues.
They're charter competent.
Yeah, they're charter competent, but the board is not competent to grant charter relief that exceeds the scope of its jurisdiction for granting relief. In other words, I think the issue in Conway was you can't issue an absolute discharge. If they don't qualify, simply because there's been a charter breach.
Yeah, it's an interesting case, especially as usual, where the rubber hits the road. We're charter competent, yet a statutory court. We have no inherent jurisdiction. So the analysis in Ontario typically goes, well, in the event that the breach or whatever the problem with the charter is proved, would the board be able to provide the remedy? And if the answer to the last question is no, then the first questions become rather moot.
Yeah. I mean, this case has been used much more widely and relied on more widely. I think outside of the review board context, it's because it's applied in respect of lots of administrative tribunals that are deciding issues of law, and that makes them charter competent unless otherwise that jurisdiction.
I think Madam Moderator may be signaling to us that
I
we're into
will
overtime.
be able to email all the participants your cases. And so.
Sure.
There's the stick. If you would be so kind, that's great.
And thank you on behalf of the Law Society for.
Well,
this
thanks for
presentation.
having us.
Yeah, it was
Appreciate it.
it was very convenient. We could grab Justice Schneider at a weak moment when he was here, but very accommodating. So yeah, thanks everybody for attending.
Thanks, everybody. Excellent questions, I must say.
Yeah, really good.
Excellent questions.